Ladies and gentlemen, welcome to another edition of Oval Trade Talks. I am joined today by Professor Gregory Shaffer. Professor Gregory Shaffer is one of the leading scholars in the field of world trade law, and he has wide experience also in the field of transnational regulation, globalization, and in the tradition of legal realism, socio-legal studies. Professor Shaffer is who introduced the concept of public-private partnerships in the WTO dispute settlement system, examining how they work in the United States, European Union, and he has also served as a senior fellow at the International Center for Sustainable Development in Geneva. And currently, he is the Chancellor's Professor at University of California School of Law. Professor Shaffer holds a BA degree from Dartmouth College and a JD from Stanford Law School, and he's been very kind to spare some time for a short interview, which is going on his scholarship and some of the most pressing trade-related issues that are on right now. Professor Shaffer, thank you so much for being us for this interview.
Thank you, Rashid. It's a real pleasure.
My first question to you is with respect to the grammar of inclusion of a currency chapter within the scheme of the unspecific partnership. Now, this only has researched as long-standing fear of countries indulging in such practices, and their ability to capture both domestic U.S. markets and international markets. While it is true that none of the TTIP participants right now are considered to be currency manipulators, but any such decision may appear to be a threat to the independence of the central banks who focus on determining monetary policies. And also, it appears that there is a threat to an existing international structure which looks into currency management issues. So in this regard, my question to you is twofold. First, do you feel the negotiations around inclusion of a currency chapter in the TPP would be a deal breaker? And how do you think it would affect the existing multilateral arrangement, which doesn't recognize currency misalignment as a ground for imposing trade sanctions?
Great. Obviously this is an important central question, and it's a very hot topic within what we call the Washington Beltway today. Congress on both parties have expressed quite strongly that they'd like to see a currency manipulation provision placed into the Trans-Pacific Partnership Agreement. And so the question, trying to read the tea leaves as to how important ultimately this is for Congress is a very difficult one. It's a very complex area. In this new book of mine, Transnational Legal Orders, we have a chapter called The Misalignment of the International Trade and Monetary Regimes. The international trade and monetary law are interlinked, which is the reason why you see this concern for Congress, because if you reduce your tariffs by 10% as part of a trade deal, and then the currency valuation changes by 10%, the commitment completely has been changed over. And so this was a concern back when they created the original GATT before the WTO. And they wrote provisions into the GATT and into the Bretton Woods agreements and the IMF agreement. But that was a system based on pegged exchange rates. So that you had exchange rates were relatively fixed, and actually formally they could only be altered with the IMF's approval. But we live in a different world now, where after the Bretton Woods regime exploded in the 1970s and 1971, because of U.S. action, that that without a system of pegged exchange rates, every country has the right, and that they have the right under IMF rules to choose their own exchange rate regime, be it a floating regime, be it a pegged regime, be a semi-pegged regime. And so they have that discretion to conduct their own macroeconomic monetary policy. And we have a shift towards, sort of movement towards central banks, which are increasingly separate from politics, and with the authority to determine, to target monetary policy to address inflation rates and so forth, and to potentially build up reserves as well. And this, these central bank actions, of course, each intervention by a central bank can have externalities, impacts on trade, so that if a currency value goes up or goes down, that's either going to prejudice or provide benefits to its particular export interests. And so this has been with us for a long time. It's really become an issue more recently, politically. And it's become a very big issue in Washington. There are a couple of economists at the Peterson Institute have been doing a lot of work, which has received a lot of resonance both within Republican and Democratic representatives in Congress, but particularly the Democrats. And so it's they're demanding action. They're demanding action, as you noted, not so much because of the members of the TPP itself, but because of China. They're focused on China, and this seems to be the great the animating dynamic now of both the TPP and U.S. trade policy generally. And so it's a bit ironic in some sense that TPP is addressing an issue which is targeted at a member, at a country which is not a member of the TPP. The challenge, of course, is actually operationalizing this, defining what is currency manipulation. Because actually the two authors, Bergsten and Gagnon of the Peterson Institute, do mention TPP members. So they are implicated, and they know this. So they pointed the finger at Japan in particular, but also at Korea, South Korea, also at I believe at Malaysia as well, and at Singapore. So these countries realized that potentially they could be targeted. They were particularly targeted by the economists who wrote the background materials, which has gotten the interest of Congress. Everyone knows that there's going to be certain externalities, at least in the short term, with respect to currency fluctuations. And that government monetary authorities and government interventions can affect currency rates. The question is how to discipline them, and how to discipline them potentially through law. What's being proposed in Washington is to do it through import relief measures, so that you can raise tariffs if you believe, or your authorities believe, that a trading partner is manipulating its currency. The traditional ways of doing this is either through a countervailing duty proceeding or an anti-dumping proceeding. If they do it through a countervailing duty proceeding, which is being proposed because the currency, the intervention to shift currency rates is viewed as a subsidy to exporters to provide them with an advantage, of course, you're providing a ammunition to particular domestic industry producer interests to hire lawyers to create very long and detailed proceedings, which themselves can wipe out the benefits of a trade negotiation by raising tariffs significantly, maybe 10%, maybe 100%. And so countries who have been subjected to U.S. anti-dumping and countervailing duty proceedings are justifiably concerned about, even if there is an intellectual rationale to address potential currency manipulation, that it can be manipulated in practice for particular producer interests. It'll be very difficult to provide the discretion to a domestic decision maker to make that determination whether or not currency manipulation has taken place, when that domestic decision maker is going to be under significant political pressure to make such a finding. through congressional representatives and within Washington. That's a real concern, and no one's really been able to solve that. I don't think that it would be a major issue for the IMF itself. The IMF certainly is jealous of its authority with respect to monetary issues. Although IMF rules provide that countries are free to adopt whatever exchange rate they decide, so long as, and the IMF rules themselves say in Article 4, that they shall not engage in currency manipulation in order to provide themselves with a trade advantage. So it's in IMF rules. The misalignment of the two regimes is that the IMF doesn't have a dispute settlement system, which is binding and automatic, unlike the WTO, in which countries can bring claims, and there's a quasi-judicial process that resolves them. So this would then, if this was not in TPP, but before, within the GATT WTO, what would probably happen is the IMF representative would be called to make a determination as to whether or not the IMF views currency manipulation was occurring. This would be very politically difficult for the IMF to do because it would require a vote within the IMF, in the management body, that there was currency manipulation. And that would be not a purely legal, but also a political decision-making process. And so it's doubtful whether or not the IMF wants to be in a position to actually making such a claim before the WTO. TPP, how those rules would be written, in theory, they could be written so that once more the IMF would be consulted or have to make a formal presentation. That would result in the same challenge. If the IMF was completely cut out of this, then it becomes, and if it was to address, be resolved unilaterally through countervailing duty proceedings, it would be a fascinating issue, because if they actually were countervailing duty proceedings brought pursuant to TPP, there would clearly be a possibility to challenge these under WTO rules. Those who have signed both the TPP and are members of the WTO would not forsake their WTO rights. And so if they felt that this was violating the agreement on subsidies and countervailing measures in the WTO, you would have a very interesting case. It would have once more showed that we live in a system of fragmented international law. Here you would have particular trade agreement rules through a preferential trade agreement, and you would have WTO rules. The WTO rules are backed by a functioning dispute settlement system. TPP is more questionable how functioning that dispute settlement system would be. So far, none of these preferential trade agreements have had the same sort of dispute settlement system as in the WTO. So is it a deal breaker? It's hard to, I think that other countries, and the U.S. Treasury Department's been very clear that they don't want this. And this was back, the U.S. Treasury Department back in the Bush administration didn't want this entered into the trading system. In the Obama administration, they're pushing back on Congress. And so the executive realizes this would be problematic to try to implement it in practice. So whether or not they can get Congress to have some sort of soft law mechanism, which wouldn't be subject to binding dispute settlement, but would be subject to some sort of discussion among central bank members, some sort of quasi bringing the parties together to try to work out the challenges within some sort of framework, that potentially might work. But to simply provide deference to another country to introduce higher tariffs on whatever partner it believes is engaged in currency manipulation, that would be a challenge. The U.S. should recall that it wasn't too long ago that Brazil challenged the United States with currency manipulation because of the impact of quantitative easing engaged in by the U.S. Central Bank on Brazil and Brazilian's trading situation. And so it'll be other countries will also point the finger potentially at the United States, and this is not going to be easy to resolve, and potentially could open up also potential for all sorts of protectionist abuses to undermine whatever trade deal is actually reached.
I want to carry the discussion forward on TPP, but I want to take it in the context of relationship between India and the US. Following President Obama's recent visit to India, there is a great deal of buzz that there is going to be now a long-standing strategic alliance between the two nations. However, once you look at it from the perspective of trade policy, there are vast differences between the stated objectives of these nations. This is evidenced by the dispute, the ongoing dispute with respect to solar cells in India at the WTO. And when we look at it, India in its recent budget has declared a greater emphasis on domestic production of solar cells and is still going forward with domestic content requirements for its solar cell projects. Secondly, the very fact that it is the policy of the Obama administration to take US manufacturing products to overseas markets and possibly through the TPP route, this is at odds with India's recently launched Make in India program, which is also trying to establish India as a manufacturing hub. And thirdly, it's the TPP in itself is going to cause a great deal of trade diversion, as certain literature suggests, for Indian goods, because there would be some sort of standards which will become part of the TPP, which the Indian suppliers will not be able to meet. So do you think that we are actually going to see, or we will actually be able to maintain the momentum gained by President Obama's trip, or are we going to see a deterioration in bilateral ties between India and the US?
I think that we continue to see the same sort of situation between India and the US that we've seen for a long time. Certainly the Modi government has has appointed economists of a trade liberal advantage to high-level positions in India. And they actually are economists who've been based in the United States, one, in fact, previously at the Peterson Institute, and the other at Columbia University. And so that there's a sense that India, you get a sense that the Modi administration would like to ease the conduct of business generally for investors in India. And so I think this is more important in some ways than trade relations, which will be opening up Indian investment for manufacturers, which would include potentially U.S. manufacturers. So in that area, I think you're going to potentially see a deepening of the U.S.-Indian relationship. Given the Indian diaspora, which we're just talking about now in high-level positions within India itself, they're closer connect. There are close ties, especially among the Indian commercial and professional elites, with the United States. And so that, and with the party now in power, that to the extent they remain in power, I think you could see a deepening of economic relations and conduct of trade. Of course, trade is becoming increasingly important for the Indian economy, significantly more, right, than in the last, than say 15 years ago, 20 years ago when India joined the WTO. Indian trade is arguably even now, last figures I saw, and I have an article with Aseem Asini, a political scientist, on the changes in Indian trade policy. Now, India, surprisingly, is basically equal or even more so trade is important to its economy as China. And everyone thinks about China and the importance of exports and imports relative to China GDP, but it's basically the same for India. So that's, given the traditional sense of India as an inward-looking, import substitution, socialist type economy, very protectionist, that's changed, and I think that's probably here to stay. The 1991 reforms that are becoming embedded, and that opens up the possibility for greater U.S. trade and investment policy. But in terms of sort of the United States and India signing into, becoming partners in WTO negotiations, that would be a fantasy, right? They still have very different interests. India has very strong agricultural interests, has manufacturing interests. It's a developing country which wants to be able to retain flexibility for its development initiatives, which you see linked to the solar panel situation, where you're speaking of local content rules or Buy India policies and so forth. These, of course, are constrained by existing WTO rules, and that's the reason why you're seeing WTO dispute settlement challenges. It's not as if India only is enacting Buy India policies. The U.S. Congress is adopting Buy America policies. And so these are the typical trade challenges that you're going to see, and that's the reason why we have a multilateral organization like the WTO. And so I see this relationship continue to deepen economically in terms of the economic ties, but the trade tensions will continue.
Moving on to my next question, and since we were on the topic of dispute settlement at the WTO with respect to the solar cells dispute, you edited a book in 2010, which was Dispute Settlement at the WTO, the Developing Country Experience. In that, what is, in your view, the common strategies that are adopted by the developing countries which assist them in winning a dispute at the WTO?
What developing countries, my own research has pointed out, are at a significant disadvantage in WTO law. It's not as, I'm a great supporter of the WTO dispute settlement system, but it's not as if law has simply replaced power asymmetries. You simply have different forms of advantages under the WTO dispute settlement system than you have in a purely bilateral diplomatic relationship. And in particular, what I pointed out was the issue of money, the issue of knowledge, and then the issue that power still remains as a residual when you're trying to put pressure on a country to comply. It's much more difficult to put pressure on the United States than it is to put pressure on a small developing country. And so the challenges then for developing countries are how, in particular, since it's very difficult to overcome the power asymmetry, is to overcome the issue with respect to money and the issue to overcome with respect to knowledge. To bring a claim or to participate in the WTO dispute settlement, you not only need to prepare your defenses or your arguments, but you have to be able to argue, you have to be able to recognize that you might have a claim in the first place. If those who don't know WTO rules, those who don't pay attention to what's taking place in foreign commerce, those who don't have relationships or linkages with the private sector so that government is sort of back behind its own administrative walls in its own capital, that doesn't know what sort of injuries are being suffered by their own industry, they're much less likely to be able to act effectively to use the WTO system for their advantage. And so the series of recommendations that we have made, but also we see this developing in India. So just to give an example of India. So India realizes that it's got a system of career diplomats in its commerce ministry who have career incentives to move and have career paths where first they may work in Geneva, but then they have to go work in their home region for a period of time, right? You potentially lack that sort of consistency it takes a while to build up expertise in WTO law within government, and suddenly then you're moved on to another post. And so India's tried to have a trade specialization to be able to retain expertise. But it's also realized that particularly with respect to law, the civil service doesn't have really strong, it doesn't have lawyers as part of its tradition. And so they've created basically a pool of lawyers who are largely in Delhi, some in Bombay, Mumbai, who are there to work with the government on contract generally, to help analyze potential WTO cases, to write legal briefs, and potentially even be in Geneva to work on them. And so you see this form then of what I call public-private partnerships, or relationships between the public sector that tries to enhance its expertise and its competence through working with private lawyers. The other issue is how to work with the private sector itself, because the private sector, WTO litigation is very fact-intensive. You need to be able to prove that there's some sort, what's the factual basis for your claim? And it's the private sector which is most likely to be able to have those facts at hand, and the government needs them. So you need coordinating devices between the affected private sector and government, perhaps with the mediation of lawyers between. The different countries have different institutional traditions, which mean that they work in different ways. So Brazil, for example, the private sector actually will pay for private lawyers to work with the government, and then the government will formally bring the case. And so you saw this in the famous Brazil cotton case with respect to challenging U.S. cotton subsidies, or the EU sugar case where Brazil challenged EU sugar subsidies, where they hired lawyers, but the lawyers were paid by the Sugar Trade Association, the Cotton Trade Association. The government, of course, had the responsibility to make sure that the briefs represented Brazil's interests and not just its trade, the sugar sector's interests or the cotton sector's interests. And this is a negotiation. It's a complex one. But the government realizes it can't do it itself. India, on the other hand, the government has, for the most part, paid the legal fees, which means that lawyers don't get paid as much as they do if the private sector pays their fees. And it creates different types of incentive challenges, but India is trying to manage this by working with this pool of lawyers, one of which, Lakshmi Kumaran, recently opened an office in Geneva, which to my knowledge is the first law firm of any region in the world outside, or outside of the United States and Europe, to open an office in Geneva. And clearly its interest is to represent India in particular cases, but also other developing countries. The other institution that really came out of this book and the work that I've been doing is the Advisory Center on WTO Law, which is it's an international organization based in Geneva, consisting of I can't remember, 7, 8 lawyers, who can provide assistance at different legal rates, which are subsidized legal rates for developing countries. And the least developed countries get the best deal. And then as you become have more resources, you still get subsidized rates, but compared to the rates of private European and U.S. law firms. But nonetheless, you get a group of lawyers who don't move in and out from WTO law to something else. They are repeat players. They acquire knowledge of WTO jurisprudence over time. And so even if one developing country only has a case maybe once every 4 or 5 years, they don't have to have that internal legal expertise in their trade department, which simply doesn't make sense to invest in because they don't have as frequent trade disputes, say, as India, the United States, China. But they can tap into legal expertise in Geneva. It's not as perfect as having it completely internally in your own government department, but that's the disadvantage that developing countries face, and they try to overcome, fortunately, through the existence of this particular institution.
Professor, I want to take the discussion to the TTIP, and within the TTIP, the most contentious issue right now is on the inclusion of the ISDS clause. Now, the debate with respect to the ISDS clause is not a new one. It is essentially that whether the foreign investors should be given greater concession or the regulatory sovereignty of the host state should be given greater concession. In this regard, a Swedish economist by the name of Frederick Eriksson argues that perhaps if we move towards a multilateral system, a rules-based system for investor-state arbitration, something similar to the WTO dispute settlement system, then that would allow us to balance the interests between the rights of foreign investors and the rights of the host state. Do you believe that any foray into a rules-based system for investment arbitration is going to settle the debate on this particular issue?
Well, I don't believe that it'll ever settle the debate because sovereignty is too is an issue which politicians can latch onto at any time, whenever they lose a case involving an international forum and non-domestic fora. So the ISDS, ISDS has some parallels to where we started this interview, right? We started this interview with respect to currency manipulation, putting it in TPP because the interest was China, which isn't a member of TPP. ISDS, what U.S. authorities and European Union authorities are saying, we want to put it in TTIP, not because we're concerned about each other, but because we need a model to apply to China. And if we negotiate an investment agreement, which we are negotiating with China, China will simply say, well, if you don't have it between yourselves, why do you need to have it with us? And so we need to have it as a model to the world. That's the argument. There's been many critics of ISDS, of which I am one. And it's because of the way the system is currently set up, which has all sorts of perverse incentives. So that regardless of the good faith of the participants in the process, the incentives are all wrong. The challenge with the incentives, of course, is that the arbitrators are paid by the firms and who are bringing the disputes, as well as the governments. Right? But because if the firms are bringing the case, it creates a certain incentive to provide a sense that their future cases may come your way, right? Or at least there's a suspicion of that. And that you don't want that sort of suspicion in any rule of law type system. So the question is how to overcome, how to change what's now an ad hoc system where investors pay the arbitrators to hear the cases that they bring, which has, one, this challenge of incentives, and two, this challenge, the challenge of inconsistency. And where there's inconsistency in terms of the interpretation of provisions, where panels, potentially, two panels hearing a case brought by different parties but involving very similar factual situations, reach diametrically different opinions, that not only is inconsistent, but it's incoherent and calls into question the very rule of law. Any system faces this challenge, right? But so we have district courts and circuit courts in the United States coming up with different opinions, right? But they're resolved hierarchically through a Supreme Court. We need some sort of appellate body mechanism for investment state dispute settlement, which the Swedish economist you cited put forth, and I agree that that's a central aspect for reform. The other is we need clear public policy exceptions, right? Much clearer that exist in the current bilateral investment treaties. The reason why they don't exist in the current bilateral investment treaties is because they were their models are from US and European, German models signed with developing countries in completely asymmetric relationships where the United States is not worried about US or European public policy being challenged by a Bolivian investor, right? Rather, they're simply interested in protecting their own investors. What's wonderful about TTIP is now you have a symmetric relationship where you have an opportunity to put in real public policy exceptions, such as we see perfectly, but much better in Article 20 of the GATT for public policy exceptions than you have in the current bilateral investment treaties. So you add those sort of public policy exceptions, which provide deference to member state sovereign choices, and you have an appellate mechanism. And I think this is an institutional advance over leaving everything to domestic courts, because we know that there's incredible pressure on domestic courts to decide in favor of domestic interests. That's the reason why we have third-party dispute settlement at the international level. The trick is how to create confidence and trust in that system, and you're not going to create confidence and trust if it's an ad hoc system with arbitrators paid by the claimants who reach inconsistent results.
Coming back to your scholarship on WTO and transnational legal orders, you recently published a paper on how WTO shapes regulatory governance, and it is essentially arguing how exploring the role of legal norms and how they institutionalize at the transnational, national, and local levels. And at the same time, how norm making in these levels interact both dynamically and recursively at the same time. Could you tell our audience about how WTO has changed this and established new legal norms at these levels and the pressures that underlie any such process of convergence?
Yes. So this is a central area of my research now, which is on what I call transnational legal ordering, or the creation of transnational legal orders. Most scholarship, be it in law or political science or economics in the WTO, really only looks at the international plane. It looks at the negotiation of the WTO rules, what the WTO, quote, contract says, contract between nation states, and then looks at dispute settlement. And then it might ask, well, do countries comply, and how frequently do they comply, or how much do they comply with the reports issued by panels in the WTO appellate body? If WTO rules are really going to have an impact, or if any international rule is going to have an impact, be it bankruptcy, secured transactions, human rights, environmental treaties, and so forth, they're going to have to enter into the domestic system. And so what this particular paper, the project, looks like is what sort of implications does it have for institutions within nation states, within norms within nation states, and within professions within nation states. And to the extent that you harness institutions, professions, and norms, you're much more likely to see a form of convergence and a form of much deeper cooperation than if you're purely talking about an international contract with international dispute settlement. And the argument is we should explore what are the much deeper implications of WTO law. And of course, this is going to raise both concerns with respect to WTO critics because of these much deeper implications. At the same time, to the extent that the WTO actually has an impact and one believes in trying to check externalities of national decision-making on outsiders through a third party such as the WTO, one wants to look at the institutional changes within nation states. And so just to give an example with respect to India, you see with the WTO, the relative enhancement of the Department of Commerce, sort of attracting expertise. You see investments in in building what I call legal capacity within the Indian state and with its relationship with private lawyers and firms. All of this harnesses professions, right, to take into account in a much deeper sense WTO rules. They know about WTO rules. That knowledge spreads throughout different ministries. So you create India, another institutional change you see is mechanisms to where the different ministries get together whenever they see implications for trade policy. And now my understanding is that when major cases come down from the WTO, India will have ministries get together to look at the implications of these decisions for Indian policy. So before it was terminated and replaced, the Planning Commission, even the Planning Commission, which was considered so powerful within the Indian state, and which in the past would never look at the international rules or international dispute settlement in terms of their implications for power policy or sort of major developments, infrastructure developments in the Indian state. It started to look at these, and it actually asked for memoranda from outside lawyers in terms of its alternatives. And so that's that harnessing of one sort of taking into account these international norms, not only within the trade bureaucracy, but within other divisions, institutions within Indian government. That's quite powerful. You see within India just the major challenge, which I find, for once again, for better or for worse, is intellectual property and patents. It used, India, this was incredibly contentious area of TRIPS with respect to pharmaceutical and patent rights for chemical products. Now you see it's sort of this major shift in India with respect to innovation policies and the government having talking about the innovation decade. And you see a shift in the interest of pharmaceutical companies themselves investing, changing their business models. And so you hear from time to time declarations now. I've heard in government one interviewee saying it used to be with patents will perish, now it's patents or perish, right? And so you see sort of shifts. And of course you have now intellectual property lawyers, you have many court cases and so forth. Or the legalization of import relief measures in the anti-dumping cases, the number of those. So that protection in India used to be through what was referenced as the license Raj, with sort of a non-legalized bureaucracy making decisions which never involved lawyers, or very rarely did, with respect to what providing licenses for import or export. Now, to get import protection, you see the hiring of lawyers, you have legal staff and accountants within the government, you see books being written by lawyers, you're seeing, actually India has more Supreme Court cases with respect to anti-dumping measures than any other country in the world. So you see this real legalization of the process, which of course then means that professions have invested in this particular area. And you see a shift, right, from a sort of non-legalized license Raj to now if protection is sought, it's done in this particular legalized realm involving new norms, new professions, and new institutions.
Professor, coming to another paper that you wrote, and this is on the authority of the appellate body. You argue that while and I read it with great deal of interest, and I completely agree with your central hypothesis in this paper. You argue that while the appellate body has developed itself as a unique dispute settlement system, a very sophisticated one at that, but at the same time, it remains very, very fragile. Could you tell our audience why you feel that the appellate body is susceptible to this sort of fragility?
Yes. I mean, first, I think we need to recognize just what an experiment this was in international relations to create an appellate body. And how remarkable it's been to see the legalization of international politics where powerful nations resolve their disputes, including China and the United States, through law. Right? Something, if you think about the South China Sea disputes, how difficult it is to try to resolve these disputes through a third-party dispute settlement system. But here we have it, and the appellate body obtained remarkable authority. So the paper is really part of a broader project on the authority of international courts. When do you see international courts? What provides them with relative authority versus being ignored, right, or rarely used? And so here we have a system which is pretty remarkable. And the paper documents sort of this, what we call rapid leap from narrow authority under the GATT, which only involved a few parties, and only for that particular case, to the development of a jurisprudence where everybody takes account of that jurisprudence, right? There's articles written on that jurisprudence. There's in India, there's working groups assessing both in government and this small group of lawyers analyzing the results of this jurisprudence, what it means for current Indian policy. That's a form of authority of a court to determine, in WTO parlance, clarify what the law is. But in clarifying it, it has implications for future disputes, and everybody knows it. Everybody argues it. And so the concern, though, is that this body, of course, the concern is twofold. One is, with the political process broken down, if countries disagree with a holding of the appellate body, and that appellate body has clarified what the law means for future disputes, that body is quite powerful. And so there's been concern to try to rein that body in. And of course, the leading country in this, in my view, has been the United States. And it's been the United States with respect to its concern over its import relief laws. So issues that seem relatively technical and minor, perhaps to many, such as what's called zeroing, which creates biased calculations in anti-dumping proceedings, or what's referred to as double counting for subsidies and countervailing measures to be able to have impose higher tariffs on China. These, within the United States Trade Representative and within Congress, have catalyzed rebukes, strong rebukes against the WTO appellate body. And in my view, that's quite unfortunate, because it appears that the aim is to undermine the authority of the appellate body. Of course, undermining the authority of the appellate body may provide certain leverage for the United States in its anti-dumping proceedings, but it also is going to undermine the appellate body's authority when the U.S. has interest in other countries complying with WTO rules, in particular China, which Congress is very concerned about as well. So you can't ask China to respect the authority of the appellate body when you yourself don't. And this double-edged aspect of international dispute settlement, which makes it very interesting. But the challenge is, with the rise of China and concerns in the United States and India and the other BRICS, and the concerns in the United States about the relative loss of economic clout globally, these issues of quote sovereignty, right, are rising once more, and that's never good for a multilateral institution.
Professor, my last question to you, and I have asked all the panelists who have joined me for the talks, I've asked them solely with the objective of assessing what the general mood is with respect to TPP and the future of the WTO in the event of a successful execution of the TPP. So do you think a successful TPP would mean a diminishing of the legitimacy of the WTO?
Of course, we don't know, but my intuition is no more of a reduction than we already see. The reduction's there, right? The reduction's there in the sense that countries no longer see the WTO as the place for negotiations, and so many diplomatic resources are being placed in negotiations outside of the WTO. And this, of course, takes away from the prospect of negotiations within it. So it's no real change, right? This has been taking place now for a long time with the proliferation of bilateral investment treaties and preferential trade agreements and so forth. This just happens to be a bigger one, a much bigger one. So it potentially could go the opposite way. It could provide momentum for future WTO negotiations, especially if China has its own parallel agreement and Europe does, potentially. That's clearly, I think, part of the plan of those who are negotiating it. But bringing these issues to the WTO won't be easy either. And so it's my same concern with respect to the question just before. To the extent that WTO still has a system where you can engage in certain marginal negotiations, such as on trade facilitation or government procurement. And it has a monitoring system for its core provisions. Many of the provisions in TPP are simply going to repeat what's in the SPS and the TBT agreement. They're not going to add that much, which is new. And to the extent that the WTO remains the locus for dispute settlement, then the WTO has an ongoing important mission. But there's real concern by the trade diplomats that they don't want to turn this purely into a dispute settlement system mechanism run by lawyers. And that's the reason why I believe that you see the diplomatic community putting no longer sort of supporting the appellate body as they did. And I believe that Europe still is, but the United States is not. And this is my concern, that, and it goes back to an old theory in trade law, which maybe we'll end with, which I don't want to believe in, called the bicycle theory, that if you don't continue multilateral trade negotiations, everything will fall apart and we'll revert to a world of protectionism and to the chaos of the interwar period, which led to the Great Depression. I hope that's not true. I don't think it has to be true. But if you see energies move to other fora, leading to alliances, trying to isolate China and undermine multilateralism, and then this has a fallout effect because you can't revise the rules politically, and there's discomfort with the appellate body continuously clarifying them, which then leads to the undermining of the authority of the appellate body, that would be a bad day, not only for multilateralism, but for the global trading system. I hope
Professor Shaffer, thank you so much for joining us for this interview. It was indeed a very, very enlightening session, and I'm sure our audience is also going to be very, very enlightened by the discussion that's taking place in today's interview. Thank you so much.
Thank you for doing this, and thank you for the series. These are such important topics that more people need to pay close attention to. Thank you.
Thank you.
Bye.
Thank you, Professor.